Okay, it is about 8:31 and it is Wednesday, August the 26th, 2020. And welcome to week number 3 of business law. And I'm Professor Richard Wright. And so tonight I'm going to spend some time going over some of the details of the assignments for the week. And then I'm going to give you some information that will help you that I've noticed with the assignments. So let's share my screen. Okay, so you can see down here, week 3, there's the rubric, drinking and contract formation don't mix. Here are the rubrics for each case study, and then make sure you have APA citations in the body of each of the case studies, and make sure that you have references at the end. Not you don't have separate reference page for each one, just one reference page. Cover page as well. And please do me a favor and type them double space and not single space. Okay, so that's the week 3 assignment. We'll talk about that more in detail in just a minute. And then your rough draft for tonight. Okay, so after this, I will have the information down here for your week 3 lecture posted down here. Okay, so let's look at the course calendar so that you can see course calendar. This is where we are right now. Your reading was due on Monday, chapters 5 and 6. The initial post, defective agreements, your live lecture now, and then reply posts for defective agreements on Saturday the 29th. Then your written assignment, drinking and contract formation don't mix. So I shared the rubric. Make sure you check that as well. And then for the course project, your rough draft. Okay, remember what you're going to be doing. You're going to be preparing a contract. So let's go back to the course home and let's look at the announcement. So we're going to deal with illegal agreements, chapters 5 and 6 of the textbook, Essentials of Business Law. And we're going to go over a little bit of the illegal and defective agreements and the flashcard, show you how some of his answers work. Then your discussion assignment, what are defective agreements? We'll talk about that in a minute. And then finally your written assignments, drinking and contract formation don't mix, and then the rough draft. Pay close attention to the rubric. I remind you again. And then you know about my motto here as well. Okay, let's close that down. And let's go to the module itself. Okay, one of the things I do want to remind you guys before I actually go into the assignments is your assignments are due on Sunday, 11:59 p.m. Central Standard Time. That's when your written assignments are due. Now, if they are not turned in on that day, the next day, every Monday, I do what we call a scrub. And what I do, and this is for the benefit of your advisors, and it brings attention to yourself too, of something, I include a 0 for every assignment that is not completed. I have had students who believe that when they see that 0, that they might as well just forget trying to turn in the assignment. That is not true. You do still have time to turn them in. Remember, we talked about the late assignment policy the first week. The 0 is the grade to let you know and bring to your attention. I can always do what we call an override when you turn in the assignment and I grade it, then I can adjust the grade from 0 to whatever it is that's based on the quality of the assignment turned in. So I'm say this again. When you see the 0s, that does not mean that you can't. And then students constantly send me messages on Monday saying that they want to know if they can still turn in an assignment. You can still turn it in. Remember, the policy says up to 7 days. But remember, what happens if there is no extenuating circumstances that you're going to have a bad grade. The point of the matter is that 0 is a placeholder. And when you see that, it also brings to your attention and your advisor that you're not doing the work. So get that clear. And I won't repeat that anymore because I want you to be sure that you understand the purpose for that 0. All right, because you'll see 0s, many of you, for week 2. And reason is because on Monday, well, actually, you'll see them now for week 3 because the assignments, we keep moving forward each week. Okay, so yeah, for week 2, because your week 2 assignments were due the 23rd, which was just a few days ago. So starting Monday, your assignments for week 2, if you haven't turned them in, you will see 0s, okay, for them. But that doesn't mean you can't turn them in. All right, let's go over the assignment. So let's first talk about the rough draft. The rough draft is a part of your project. And so last week you were introduced to the course project, and you had to do a little chart thing. And now you're going to take the negotiations between yourself and Mr. Barker. And let me move Jeff out of the way there. And you're going to take the job of drafting a contract that'll finalize the deal. And this will give you an opportunity to practice how to draft a contract. Now, based on the information from the worksheet of last week, you are to build a written contract. And so you'll need to include this information in here. All right. And very, very, very important. All right. Every one of these items. Now, you don't um, you don't have, you can do this contract single spaced if you want. That's fine. I don't mind the contract being single space because that's how a lot of contracts are. If you want to do a double space, it's okay. But make sure that you take the information from what you completed last week. All right. And besides the things in this list, you're going to include a clause that's mandated alternative dispute clause. Okay. And if you don't know what that is, it's in your book. It tells you what that is. Or you can research it and it will tell you what it is. I know what it is, but I'm not going to tell you what it is. Now, here's what I recommend for contracts. And I always say this, caption them. You know, you can number them if you want, but if you say parties, put in a caption parties and maybe, bold print, underscore it or something, and then fill in the information. Then dates, the same thing. That's how you do it. If you looked at any contracts. Now, the other thing that you're going to put in is called an act of God or force majeure clause. In the case the toys are destroyed by a natural disaster or something happens. Now, there is something that you should be aware of that I want to bring to your attention that will really be bonus for you to put in. And I'm not saying bonus points, but it will mean that you're really on top of things. There is something that's going on right now that force majeure will apply. Does it? Are any of you, or do you know what type of incident or act that I'm talking about right now? That would fit under this section of a contract? Yes, but that's all the time. What else? There we go. That's it. As a matter of fact, if you do some research and Google, you will discover some discussion about force majeure and the pandemic that is going into contracts now that didn't happen before. Because you're going to discover when you do your research about the acts of God, force majeure, you're talking about things that are beyond your control that happen that prevent the performance of a contract. Would you say that the pandemic fits very well into that at the present time? Very well. So that's something that you should know and be aware of. And you know, I want to see. I'm going to be looking for some mention of that when I see this, because I mentioned it in the lecture. Now I know what some people are going to say. Oh, I didn't see that in any of the stuff that I looked at. It's there. It's out there now, and there's a whole lot of discussion about force majeure and the pandemic. For example, let me tell you something because I had it right here. All right, majeure. Mm, okay, okay. And so there's you can check and you could see that force majeure is mentioned in a lot of articles, law review articles, um, and generally it includes things that, like what you had said earlier, hurricanes, tornadoes, storms, floods, And, so things that are what they call force majeure, or what they're saying is major forces, and acts of God. And this is not about whether you believe in God or not. This is about and something that's beyond our control, like the pandemic. And so how these clauses are included in there. And so this is what I've read. It says, in response to COVID-19, federal, state, and local government entities have imposed various um, containment strategies that will undoubtedly have a trickle-down effect on a company's ability to perform contractual obligations. The federal government has placed travel restriction on international travel, domestic, individual states and cities, closing schools, restaurants, and bars, and prohibiting gatherings of more than 50 people. These strategies intend to slow the spread of COVID-19, may eventually lead to the workforce and resulting in supply shortages. It's not may, it has already done that. Parties facing these shortages may point to these effects to avoid contractual performance, depending on the specific language in a force majeure um, provision. So you're going to look at the clause, analyze the clause, and you're going to find it. It's been in there for years and years and years and years. But these are very important. So here's what I want you to do. That's why I say you don't have to number them, because this would be number 9 and then number 10. But here's my point. Very, 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 very important. And find yourself um, highlighting, like I say, a mandated alternative dispute clause, and then write what it is: an act of God or force majeure clause. In the event that the toys are destroyed by natural disaster, or now in the case when you're dealing with the pandemic. And so you're going to submit this according to the rubric that we've looked at already. And while it's fresh, let's go back and take a look at it, which I already sent you the rubrics. You should have downloaded them. So I'm going to go to the rubric for the course project. Okay. Here it is right here. So it's written and formatted as a formal contract. Form it as a contract, okay? Look at how contracts look. Relevant parts, and it tells you what they are. Made progress toward including these required clauses, and all the prices and quantities are accurate as described in the fact pattern. That should help you from using what you did last week. And remember, there was some information last week that wasn't in the fact pattern, and it doesn't mind if you put it in there. Whatever material information that you used last week, use that. So this chart that you prepared last week, going back to it, just to refresh your memory. Your worksheet. And this is your assignment that you did last week that I will be grading this week. So this is a very simple thing. So you have to just fill in the information, party names, the date of the contract, the addresses of the parties. Remember, we talked about how you deal with that. Description of the items purchased, the date of the delivery of the items. Now, can't you see that based on the date of the delivery of the items, that force majeure or act of God could create a problem in performing the terms of that contract as written? Can you see that, how that could happen? That's why it's in the contract. That's why it's important for you to understand. And what it does is it gives you an opportunity to, depending on the circumstances or the effect of the force majeure. Of course, if the act of God or force majeure destroys the toys, obviously there's an out for that in the contract. You can't make a person perform. It's just like a person who is buying a home and recognizing that that home, by the way, if you purchase a home, does it have to be in writing to be enforceable? And that's because of what you learned from a theory of law called what? It was the key word last week. You remember? Spent a good deal of time last week in the lecture going over it. What do we call that? That requires that purchase of that home be in writing. What do we call that? Because of what? Because of the what? How about statute of frauds? I know the light bulb comes on then all of a sudden there. Yeah. Yeah. Which I recommend, by the way, that you have your sheet printed up and have it. And so you remember it's my legs contracts of for M is for what? Anybody you remember? What kind of contracts? M. You have a spouse or know someone who has a spouse. They are what? Marriage. And it's my legs, remember. Y is for contracts that take uh, a year or more to complete. And then G is for what? Goods over $500. S is for surety ship or insurance contracts or either a bond. And S, so that's it. So it's my legs. Just remember that. That's how I remembered it from 40 something years ago when I took the bar exam. So anyway, the point of the matter is that you're dealing with these particular things. So you got an agreed upon price of what it is here. And this is your worksheet. This is your worksheet. And then, by the way, just for you to know, other than the items listed in the sheet, what else uh, uh, need to be present to make this a valid written contract? And, you know, we talked about those things last week. And then why does this contract need to be in writing? That's where you get into using those elements. Now, don't leave it behind in week 2 because you're going to have to keep this. I want you to learn this and remember this because this will carry you on for years and years down the road, I promise you. And it'll be a convenient way for you to remember how and why contracts must be in writing to be enforceable. Okay, so, and the reason why this one has to be in writing applies to what letter? Or letters. It could be more than one. But what jumps right out at you? What's the agreed upon price? Yeah, okay. But what's the agreed upon price? What's the agreed upon price for this? This assignment you're going to use this week that you used last week. Oh, I'm still in there, but I'm coming out of there. I'm coming out of there. Tell me. How much is um, how much is the activity that you're dealing with this week? The local restaurant. So, and what's the price for the toys? Okay, so that falls under G. That falls under G. Okay, all right. All right, so that's from last week. Okay, now let's go back to the assignment for this week. But I was trying to show you how they interrelate and how it's clear. And so as you put together that contract, you understand, I'm trying to get you not only just to complete the information, but I'm trying to get you to relate to why this is, why the dates are important, why the payment provision is important. You don't have to put that in the assignment, but these are things that you understand. And the information that you developed last week and learning about the statute of frauds is very valuable in terms of it. Okay. All right. So that's the assignment. Any questions about the course project for this week? Okay. All right. If you forget, all you gotta do is go back and play the recording because it's there. I break it down and overlap and see what I'm doing is connecting. I don't want you guys to complete an assignment and not be able to relate it to the following week. It's just like if you're building a house, I want you to start at the basement and build all the way up to the roof. But I want you to remember every step that you did to get there so that when you have a completed project, you understand not only the terms of it, but how those relate and connect in the application of business law itself, the principles behind it. And statute of frauds plays a big part in it. Okay, so that's that. So you got everything there. And then let me move you up again some more. So then drinking and contract formation don't mix. So here's the deal when you do this assignment. You're going to read each of these studies and answer the questions and use the appropriate legal terminology that you learned. Okay. So I'm just going to give you an idea. Steve and Bill go out drinking. Okay. After Steve has had so many drinks that Bill knows or should know that Steve is very intoxicated. Steve says to Bill, I'll sell you my house for $100,000. Bill accepts. The fair market value of Steve's house is $100,000. We'll still be able to void this transaction. There's two reasons why that Steve can void this. One relates to capacity, and the other relates to the statute of frauds. Because you're not assuming that, oh, it says he is drunk and he says, I'll sell you my house. And Bill accepts. The fair market value is $100,000. So forget about the goods over 500, because you go right to the one that fits perfectly with it. And we already know what that is. And that's what letter of the statute of frauds? What letter? Type it in. What letter? S for suretyship? No. You know what suretyship is? That's an insurance. That's insurance. What letter fits perfectly into this? You should have your little chart there. How about L? Isn't this a L right off the bat? Boom. Yeah. But I'm trying to say, that's why I'm telling you, that's why I gave you that information. I said, because, oh, yeah, this will open up a bulb. So as you read this, you should say, okay, I see some, yeah, I see some problem, but L is the letter. And then it tells you, based on the information, what L stands for that we talked about in the lecture, and that what I handed to you last week to keep as a sheet yourself. You read this right away, and light bulbs should start coming on. It says, all right, the drinking, red flags should be coming out. Start to think about, remember we talked about capacity last week? You remember we was talking about capacity? And that should pop out, bam. And then he's told him, he says, I will sell you my house. Bill accepts. The fair market value of the house is 100,000. Will he be able to void this transaction? Yes. Number one, if he never put in writing, number one, he can void it. Number two, well, I'm actually giving you the details, but I'm trying to explain to you how you're going to take each of these scenarios. Okay. Now, if you begin to read on in the second one, you see something, and I'm not going to do the assignment, but I see something that jumps right out at me. And then the same thing for study number 3. So what you're going to do is you're going to use the appropriate legal terminology that you learned about what applies. I want to see that you understand it. I've given it to you. I've broken it down to you in the lecture. I've given you materials to support, and you give it back to me. Give it back to me. And then use citations in the body and references at the end. Okay. Make sure you have a cover page, and if you're going to need to do that. All right. Any questions about the written assignment? Because what's going to happen, and it happens every week with this assignment that I've done, the teaching of this class, and I haven't taught it in the last couple of years, but every time I teach it, and they have me teaching it, when people do this assignment, they tell me stuff like, well, Steve is too drunk to know what he's doing. I said, okay, what is that? What's the legal terminology for it? He's too drunk is not the legal terminology. Capacity. Explain what capacity is and how it applies. And then explain what capacity does. Is it voidable or does it make a contract void? And those kind of things are what I want to read in each of these case studies. All right. All right. Now, so and then the discussion assignment. Mistakes often happen with little or no consequences. Unfortunately, in the world of contract law, mistakes can be costly. Depending on the type of mistake, the contract may or may not be voided. So this week, you learned, because I'm going to talk about in a few minutes, and in your reading, which mistakes will be upheld and which ones are voidable. Okay, and then in your initial post, discuss whether or not the contract should be voided based on mistakes. Specifically provide and information. Provide an example of a mistake in contracting that would or would allow to be voided. And then you can get creative with your examples as well. So your initial posts were due yesterday and reply posts Sunday. Sorry about that, Saturday night. And then your live classroom lecture. And those are your assignments. All right. So now let's get into what we call the meat and potatoes here. Let's talk about this. Again, your reading in 5 and 6 will help you along with what we talk about today in the lecture. So we're going to deal with illegal and defective agreements. And then I'll do the activity and then we'll close out. We've already talked about the rough draft. We've already talked about this, and of course this. So now, illegal and defective contracts. So remember, as I said before, remember the four corners doctrine. I put that in with your statute of frauds. And the best practice that we remind people are, if it's not in writing, it didn't happen. And the reason why is because there are contracts that oral that are valid, but written contracts, we try to get you into the habit of doing, even if it's just, you don't have to have a lawyer to do it. You can do it yourself with the key terms that you learn in this class, that you can write one out at a restaurant table. Try to not to do it in a bar and stuff like that, especially when there's some drinking involved, But written contracts, we try to encourage people, because if you guys you've seen Judge Mathis, Judge Judy, and these other judges in people's court, and I talked about this before, one of the things that they always ask is, do you have something in writing? And the reason is because the written document will last quite a while. I have here a contract in my hand that I had some work done in my house, and it was some flood work where the basement where I'm sitting at now was flooded, and I hired Roto-Rooter to come in. And so what Roto-Rooter did was they gave me this document, and they had all the language in here on this page. But on the back were terms and conditions, and it spelled out the things that I had to do. Told me how I could cancel it, and it talks about the warranties. But these things were in writing. These were in writing, so that if there is an issue, then the document is a memorandum of the stages of everything that involves in the contract. says, even if all the requirements of offer and acceptance are present, a contract could still fail due to it being illegal or a defective agreement. And so we're gonna talk about a few of those. And there are times when a third party becomes involved in a contract or thinks it should be included in the contract. So written contracts. I remember the late Ray Kroc, who used to do business with people. Do you know who Ray Kroc was? You ever heard that name before? Business students should learn who he was. You know who Ray Kroc was? The founder of McDonald's. And I got to know Mr. Kroc personally because the law firm I worked for represented McDonald's, and I took a package to Mr. Kroc, and he made me his personal messenger, and I learned a lot from Mr. Kroc about how he organized McDonald's. You know what I found out? He had people that he dealt with. In fact, one of my good friends started out with him, a guy by the name of Willie Wilson. And Mr. Kroc gave him his first franchise on a handshake agreement. Now, be aware of the fact that that was the agreement that he agreed. He said, I'm gonna sell it to you, and then he told him how much. However, shortly after that, the lawyers prepared documents to really solidify it. So the enforceability of the contract required it to be in writing, because obviously it was for goods over $500. Okay. And so my point being is this, is that the contract, he used to say that a man's word is his bond. Yes. However, though, we want to make sure that we keep things in order. And why we have business law, remember we talked about that during week 1, why there is business law and what it's all about, the importance of it. You learn that from the module itself. And so there are certain lines that a contract need to be in order to have it properly done. And notice what it says here. There are certain times that a contract must be written on statute requirements, and it says it includes all the terms and provisions of the contract under the what? Under the what? It's right here. Statute of frauds. You already know all of these because they got them scrambled up. But let's say number 5 is M, a prenuptial agreement or a marriage agreement. Okay. Number 2 is Y. Number 1 is what letter? Okay. And number 4 is what is that one? What letter? What letter? My legs. What letter is number 4? Contract which an administrator or executor pays the debts from their personal funds. What letter? There you go. There you go. And then G is number 6. And then S, the one that you mentioned earlier, is really this one. a contract to take on the debt of another, because that's what insurance does. That's what surety bonds and bonds do. You got that? So you got them all here. So you had a jump start on this from last week and earlier what I've been talking about. Do you see why I hammered it into you? Because then it gives it some formation in your mind so that you're not, see, look, guys, I am a teacher who doesn't believe in just having you do the work, but I want you to understand how you relate it to the real world. And that's what we're doing here. Okay, you got that? I promise you, years and years and years, you'll be able to have that my legs thing. I've used it. I've used it down through the years as a lawyer. I used it in court. I used it in terms of an overall life. Yep, absolutely. So these are the contracts that must be in writing. If a contract, written contract, does not exist in the above scenarios, the party run the risk of the contract not being enforceable. Okay, so that means the person, here's the deal, the person who wants to get out can get out, because if it's I'm selling you my watch for $500, I mean for $600, and you say, okay, good, we shake hands on it. But it doesn't really mean anything until we have a written document, because it's goods over $500. Buying that property, that house that we talked about earlier in the scenario, um, a contract that can't be completed within a year. So if it takes more than a year for the contract to be completed, if you're a surety ship, insurance contracts, or take out a bond, a contract in which the executor agrees to pay the debts out of their own personal, to get reimbursed for that, it has to be in writing. Prenuptial agreement orally means nothing, but we use contracts of marriage or prenuptial agreements. A contract for the sale of goods of 500 or more. Bam, bam, bam. And like I said again, when you look at this, you can put these in the proper order, and you know that if you got your little sheet that you have, you could say, oh yeah, contracts for real estate, this goes in next to L, boom. And then you go on, and it gets you to understand it. All right. Now, illegal agreements. A contract does not mean that every agreement entered into is enforceable. For example, one cannot enter into a written contract to hire a hitman to kill their boss or anybody. That contract is not enforceable. First of all, number one, not only is it not enforceable, but what would you really be doing by introducing that kind of a contract? Yeah, but what would you be? What area would that fall into? Would that fall into business law or criminal law? Yeah, absolutely. You're admitting. Now, there are contracts now in some jurisdictions that allow you to deliver marijuana, but you have to go through the proper license process in states where it's legal to do so. But if you are a regular run-of-the-mill drug dealer, like the ones I represented as a lawyer many years, then yeah, it's illegal, and so you can't take me to court to enforce it. All right, all right. If the hitman fails to kill the boss, you're not able to sue them to make it enforceable. You know, that kind of thing. So you might have some vigilante law that you deal with, but not business law. You can't file a suit in court. That would be stupid and dumb. So anyway, the contract itself is illegal, and you will now be spending some time in prison. That's what I just said. And typically the courts will leave the parties where they are instead of enforcing the contract. Probably the authorities would be called in next to have them arrested. So you'll also discover in your reading that there are other kinds of illegal agreements. Um, do you know, just off the top of your head, of another illegal type of agreement? Do you know any? Can you force somebody in a written contract to pay your gambling debts? That's one of them. That's one of them. But if you were to conduct some research and you go and you look under, just use the term illegal agreements, and some examples, you will discover that dealing with paying off gambling debts, um, um, betting, things of that nature to be um, illegal contracts. Okay, and you'll discover that. But think about this: if it doesn't better public policy, doesn't better the business world, then it's probably going to stand a good chance of being an illegal contract. Okay. Defective agreements. There's a difference between a defective agreement and an illegal agreement. Illegal agreements cannot be voidable. They are void. Voidable contracts are contracts that you can fix up if whatever the deficiency, and it becomes enforceable. Defective agreements can make a contract void or voidable depending on what the error is. Sometimes the defect can be one-sided, which means unilateral, or mutual, where both parties um, uh, demonstrate a mistake. So um, there is a number of ways. There are a number of ways. And if you take a look at this for a minute, this is something that we tell you, take a look at contracts. It says the law affords several defenses in breach of contract actions: unconscionability, mistake, fraud, undue influence, duress. And you can learn about each of these by just clicking on it, and it opens up and it tells you about um, unconscionability and how that works as well. All right. Mistake. Okay, so you can fix the mistake. Ordinarily, a valid defense for breach of contract, the mistake must be mutual, one made by all parties. However, when the mistake is obvious from the face of the contract, let's say, for example, I'm agreeing to sell you my car, and I tell you I'm going to sell it to you for $1,000. And let's say the person types in $10, and we sign the we sign the contract, and then look at it and says, oh, then you said, no, you signed it. I got it for $10. That's a mistake. Uh, so in that case, um, yeah, you have to fix that. So it says, thus a contract by its term designates a horse as a subject matter will be enforced unless parties agree that a different subject matter was intended. On the other hand, if in the same contract designates a pig as a subject matter in 99 paragraphs of the agreement, but mentions a horse only one time in one paragraph, the court will not enforce to sell the horse because it's obvious that that one paragraph was an error, because this is a contract about pigs. Okay, you got it? Okay, makes a whole lot of sense. And so remember, one of the things that is important in contracts, offer acceptance and a meeting of the minds. We talked about that before. And then undue influence and duress. So anyway, I just wanted to show you that these are some of the ways that you can see mistakes and errors that can be fixed. And then finally, third parties and contracts. Novation, assignment, and delegation are ways in which a third party enter into a contract. Typically, only the person who signed the contract have rights under it. However, there are lines when one of the party intends to benefit a third party. So that could be included in the contract. Also, there's some language in contracts where, for example, successors and assigns. You'll see that language in there, successors and assigns language. And the reason why successors and assigns is in there, for example, I'll use a mortgage. When you mortgage a house and you sign the mortgage with X bank, but then you close on with X bank, and then your 45 to 90 days or 60 days that you have that you make your first payment, then that changes because X bank is able to assign it to Y bank. So then Y bank sends a notice as well as X bank that you no longer owe them. Now you owe Y, but the same terms and conditions are applicable. You familiar with what I'm talking about? Are you familiar with what I'm talking about? Or do you need a little more clarification? Well, okay. If you have to pay X, and that's who you signed the contract with, there's usually language in the contract that allow them to assign it to another. And what happens is that these documents are what we call commercial paper, and they're able to sell them to someone else. They get the money, and then the other company steps in, but they get this. They have the only thing that changes is who you make the payment to. The terms and conditions are not changed by the assignment. Well, you could use that term, but it happens all the time in business where you will start out with so you said it could be a reseller but have to uphold it. Yeah, here's the point. The terms and conditions stay the same with whoever gets it. They can't change them because you got a new party. They are subject to whatever the original document is. Now, unless you go through, like, for example, as people do, they'll refinance, or either, like I did this with my car. I bought my car at a certain price and I paid for it, but then I was making the payments to X company, but then they sold it to Y company. Well, only thing I did was just change who I wrote the check out to. But let's say, for example, if I decided I wanted to um, get a better rate, change the terms, then I can take that and have, just like we did, I bought a car for it happens all the time. When you buy a car and then you still owe on the car and you trade it in, then the company then receives money from the company that's buying it. So there are new terms and conditions exactly based upon it. So you got it. So that's all I wanted to say about that. So now we're a few minutes over. I want you to do these exercises, but I'm going to show you. Use this activity to practice to understand it. Compensatory damages. Flip it over. An award of money designed, and by the way, remember I said you can click on the speak.
Designed to compensate the wronged party for the economic loss suffered.
Okay.
Delegate.
So delegate is next. And you can click on that and it flips it.
Who undertakes duties on a contract he was not a party to.
Okay. That's almost like what we just got through talking about. So let's say you know that now.
Delegation.
Delegation is the action of
duties on a contract to a third party.
Okay. That's what we just got through talking about. Okay. Then you put that under
delegation. Delegator.
Delegator. Or that's the person who delegates.
Who transfers duties on a contract to a third party. Doctrine of substantial performance.
Doctrine of substantial performance. The language in here tells you what it means. Substantial. And here's what it's going to tell you.
Doctrine indicating that the plaintiff may recover the contract price from the defendant minus the cost of any damages caused by the plaintiff's own break if the plaintiff can show that he or she substantially performed the contract in good faith.
So in other words, the point of the matter is that what you in your time and investment is rewarded under that theory. So
beneficiary.
So I'm not going to go over all of these, but you can do each of these. And you can manipulate it so that they play automatically. You don't know, then you can retry and you can end up getting knowledge of it. But flipping it over, this is an exercise that you can do yourself to help you to understand. And there's some things in there that we just talked about in detail that are further back up in here. I'm not going to go into those cards. Okay. So, any questions about today? All right. So, how about a key phrase? How about this? Illegal contracts. We've talked about those. So give me that and you get your points. Again, I just want to remind everybody what I said earlier. And that is this, is that if you see a 0 in the grade book next to your assignment, that's a sign for you to recognize that you didn't do it. And it also lets your advisor know. The way the process works is, as we already know, assignments are due on Sunday, 11:59 p.m. Central Standard. So the two written assignments that I'm not talking about discussion posts. Let's say the course project and the written assignment. and say you don't do either one of them by 11:59 p.m. Central Standard Time this Sunday when they're due. On Monday, I will go through and I will see who has not completed their assignments, and I will put a 0 in. Even if I've given you an extension, I still will put the 0 in. And the 0 doesn't mean that I backstabbed you or anything like that. The 0 is there as a reminder to you that you haven't done the assignment, and it can stay there if you don't turn the assignment ever in. And the reason why I'm saying this, guys, and I got to remind myself to say it in my other 2 lectures, is that there are students who will come back and they will say, one student did this on the evaluation, said that Professor Wright gives zeros one day after the assignment is due. Yes, I do, because that's a school policy. Some professors don't, but I follow the policies. But that doesn't mean to the student, if the student says, oh, okay, I got a 0, why do I try to turn it in? That's not the way it works. So I don't want people to look at and see that way. Okay. Yeah. 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 But I can tell you that there are students who are of the belief as soon as they see a 0, they think that's it. So, and then they'll send me a message asking me this question on Monday. Listen, I didn't do my assignment that was due yesterday. Can I still turn it in? Well, of course you can, because there's a late assignment policy, which we talked about during week 1. And if you forget what it is, go back and listen to week 1 lecture. You don't have to go all the way to the part where I'm talking about myself. Yeah, it's 10% off each day, but it's discretionary. It's based on my discretion as well. So students, I'm not kidding. I had one student, she went to her dean, and she told her dean, she says, Professor Wright, he doesn't give me a chance to turn in the assignment late. He puts a 0 in there. And she explained to the student, he has to. He's supposed to do that. Okay? He can't just hold it open, you know. So, yeah, people really think like that. So, anyway, you're not one of them. I can tell you that already, I know. So, anyway, I appreciate you taking the time. I wish you guys the best this week. Stay safe, especially those of you who are down in that southern part where the storm is coming through. That constitutes why some of my students haven't turned in assignments. I had one student in one of my criminal law classes who actually called me, and I had a conversation, and she was in her car. She was driving her kids 200 miles north from where she was in Texas because the storms were coming through. And I said, let me cut you off on your conversation. Yes, you can turn in your assignment late. I understand. So yeah, yeah. North Carolina. Is that where you are? You're in North Carolina? Yeah. Oh, okay. Is which one has Myrtle Beach? Is that North Carolina or South Carolina? South Carolina. Yeah, but Brunswick. Do you know where Brunswick is? It's a resort area, but it's also an area. It's right. I went there and stayed there, and then we went to Myrtle Beach, and I have all the crab legs I could eat. I forget. Bennett's. That sound familiar? Yeah, Captain Bennett's. Yeah. Love me some crab legs, but anyway, you guys have too many storms out there. So, well, all right. Well, stay safe, and I'll see you next week. Okay.